to. This is a 1-hour CE. You got to be here the entire time to get the credit, all right? So, new kids on the block. I had a lot of people ask me, what is that class about? I wrote it for new kids, for new realtors, but I teach it to all realtors because it's a lot. If you've been in the business, if you're seasoned, it's going to be a refresher. Plus, it's going to be maybe some new things that you didn't know that maybe Trek had changed or TDI might have changed, okay? So if you have any questions, please raise your hand. Ask me, holler, scream, I got a question, because I'm happy to answer. So as everyone knows, if you got in the business before 2020, you've gone back to what it now really real estate is, and it's hustle time, guys. It's hustle time. And that's the way that it is for me, anybody in this industry, for title, for realtors, it's hustle. Before 2020 and 2021, not norms. That is not the norm how real estate is. It was great while it lasted, but it's not the norm. So now it's hustle time. So getting your education and learning all these things and getting your ducks in a row, we'll talk about that, is so important at this time. Okay, let's get started. Course is going to cover earnest money and option money, title search, getting your pre-closing ducks in a row, surveys, plats, and T47s, title commitment, invoices, prorations, CDs, how to prepare your buyer and seller for closing, closed versus funded, and property, possession, and keys. We're going to cover all that in an hour. Wow. I know it. Wow, I know it. Again, you know, now is the time that you now really have to focus on your closings, your clients, your title, all of your things that really you didn't have to really focus because it just kind of was too busy. They fell into place. Now they don't fall into place. So this is why this class is really important. So make sure that you have everything in place because you want to help your clients. All right, earnest money and option money. Question. Are your buyers guaranteed their earnest money back from the title company if they cancel the transaction during option period? Are they? Are they guaranteed that money? No. No, they're not guaranteed that money. Answer is no, they're not guaranteed that money. So depositing earnest money is an option, obviously, for part of the home buyer. You deposit the earnest money and option money now. Used to, if you got in it before 2019, earnest money went to title and option money went to seller. But now Trek decided there were so many complications that they decided, okay, yeah, maybe that's not a good idea, so we're going to make it where option and earnest money go to title, which is where it should be. One thing, make sure that when I was in title, I can't tell you how many contracts that I got that option money might have been $200 and earnest money was $1,700. There was one check made out to title and the amount was $1,800. It didn't add up. So Trek says and TDI says for the first amount of money you credit to the buyer is option money. So out of that $1,800, which should have been $1,900, $200 was credited as option. The rest was earnest money. Now what happens to that now since it doesn't add up? You're out of compliance because what the buyer said they were going to deposit is not the right amount. Okay, so keep that in mind. You think they would be, but make sure that those amounts are correct. And don't count on the title company to call you and say, hey, this doesn't add up, we need more. Because they're going to send you the receipted page, they're going to assume that you see that all that's receipted in is the amount they received, okay? Don't ever assume that title is going to call you guys, all right? Option fee is paid by buyer to the title company as well. So one of the things that most title companies do, if it's canceled, if the contract is canceled during option period, the title company is going to require buyer and seller to sign a what? A release of liability. Releasing saying, okay, it's canceled, earnest money is going to the buyer. What happens if the seller doesn't sign it? If the seller doesn't sign it, if the seller's mad and says, nope, I took my house off the market, I'm not going to sign this, I'm mad, it's not going to happen, title company will not release that money. Has it happened to anybody here? I know, yep, Cindy. So title's not going to release it, all right? They're not, because it's a liability on them, so they're not going to release it. So if you're representing the seller, tell your seller, look, you can't sell your house if you don't sign it. So let's just get through this, let's move on and get this signed. But whatever you do as representing the buyer, don't tell them they're guaranteed they're going to get that money. Although someone called me the other day and she came to one of my classes and she read me the part of option period that it says if canceled, option money goes to buyer, because it's happened to her. Title sent her a release or seller release. Seller said, no, I'm going to sign it. She goes, but I call the title company. They have to do that. That's per contract. Why don't they have to do that? Remember, title doesn't follow TREC. They follow TDI. And in the contract now it says, because they put this in there in the contract in 18 under escrow, title company is not a part of that contract, doesn't follow that contract. So they don't follow TREC rules. They follow TDI rules and their rules. Okay, so keep that in mind. If you tell them they're going to get their money back, you're practicing law and they may not get it. Most of the time they are, because a seller can't sell their house and they want to sell, all right? But I've seen it where they don't and it's a big mess. So keep that in mind, okay? Let's see, I talked about that. All right, getting your pre-closing ducks in a row. Any questions on earnest money and option money? You guys are pretty familiar with that, but I want to make sure that everybody knows that title is going to require that because it is a liability on them. Okay, so let's talk about getting your pre-closing ducks in a row. One of the things that I can't stress enough about is don't ever assume title and mortgage and everybody's on the same page and nobody's dropped the ball, because it happens. It does. So please make sure that you are putting dates down and you're getting everything ready for closing. What do you think are the most common mistakes made during the closing process? Come on, guys, you know, you've had issues. Vicki?
Not getting a survey in.
Surveys?
Appraisal late.
Appraisals? Surveys?
Survey's not on the right property.
Surveys on the right property? Oh, that's a big one.
T47.
No T47, that's a big one. We're going to talk about that too, because T47s are real important. Absolutely, things happen. So that's why it's so important that you got your ducks in a row. So let's talk about this. Most common delays made during the closing process. Power of attorneys. If you know your client is signing a power of attorney, if you represent the seller, make sure you get it done immediately. Make sure you let everybody know that my client is not going to be at closing. They're signing power of attorney. And make sure you get that power of attorney to the title company, because that power of attorney has to be approved. If it's the seller, it has to be approved by the title underwriter, okay? If it's the buyer's power of attorney, who does it have to be approved by? Come on, guys, if there's a loan involved. The lender's got to approve power of attorneys, because some lenders may say no. My underwriter requires an original signature, not a power of attorney. So that has to be obviously resolved up. So power of attorneys are a big deal. I would highly recommend too, like let's say for instance, because I saw it a lot, that there was an estate situation and there was an attorney that drew up a power of attorney, okay, for the estate to be able to handle the estate. But it doesn't say in there, there's certain things that title underwriter will look at on a power of attorney that has to be in that power of attorney. So they have to approve it. For instance, if it just says they can sell the property, but it doesn't reference the property, they're going to have to redo it, because the power of attorney has to reference that that person who is signing on behalf of the other person can sell that property, has to be mentioned in that power of attorney. So keep that in mind. Surveys, heirship affidavits. All right, if you need an heirship affidavit, which I will tell you, title does not like heirship affidavits. They don't like them. And the reason why, anybody know the reason why? The biggest claim on title for underwriter is heirs, missing heirs. All right, that's why they don't like them, because the heirship affidavits from somebody that is a non-disinterested person, that's known the person probably maybe 10 years or so. Now, I'll tell you, they may know that that might be their only heirs, and they may be right, or they may lie on it, because believe it or not, people do lie. Unfortunately, so title companies don't like heirship affidavits. They'll take them, but they don't like them. And you'll have to wait a while. Let's say, for instance, if you're having someone sell a piece of property, your husband died, or it's a state situation, they just died, and they said, we don't have a will, we're going to do heirship. You're going to have to wait a couple of months because they're not going to do it right away. They're going to have to wait to make sure if any of the heirs come forward, any bills, any things like that. So you're going to have to wait. It's not going to happen overnight. So make sure you get those heirship affidavits. Missing heirs, again, got to find those people. Locating ex-spouses, got to find. It's easier now because everybody can be found on Facebook, but you got to find those people. IRS lien. Anybody had an IRS lien for a seller? Yep. It was a buyer. And that's a good point. Buyers and sellers, because title needs both of their information, they're both ran under all of the information. They're both examined. So even though you think it might just be the seller, they're going to pull buyer information too. And if buyer's in a bankruptcy or an IRS lien, they're going to pull that and they're going to show it. Getting a payoff on an IRS lien takes a long time. It doesn't happen overnight. So if you know your client goes, I got an IRS lien, make sure your title company knows right away, we got an IRS lien, we're going to have to get that payoff information, okay? Had one the other day call me and she said, my house he's selling is $225,000. He has a $500,000 IRS lien. Uh-oh. Even if he doesn't own anything on it, and he's only getting $225,000. Now, sometimes you can negotiate with IRS, the seller has to, and say, hey, got other assets, put them on that. They do a partial release. Doesn't say it's not going to close, but it's going to be a process. Child support liens are not easy to get payoffs either. You got to get those. Bankruptcy and title company receiving LLCs and trust documents. Make sure that if you're buying or selling in an LLC or a trust, get those documents ahead of time and get them turned in when you turn in that contract. All right? Any questions on this? All right. All right, sensitive timelines. Okay, please make sure that yes.
I have a quick question about the LLC documents. So whenever somebody's buying with an LLC, you just need to give proof of the LLC?
The lender's going to want that. Okay, the lender is going to want that. This is if they're selling in an LLC or an estate or trust, the title company is going to want that information. The lender's going to want that information if they're buying in a trust or an LLC, okay? Title may ask for just showing that they can purchase that. It might be on Schedule B asking for that information. Then they'll have to get it, but they'll get it from the lender. But the lender will have that. And they'll always go through the lender to get it because it's a lot easier because they know the lender has that information, okay? You bet. So, sensitive timelines, escrow, option, and an option period. So when I was in title, and I would always get a call, say, well, turn in a contract and they're going to drop off the earnest money and option money. Okay, good. How many days do you have? 3 days. All right, and you know how crazy it was in 2021. There were multiple offers and everybody was going crazy. So I had a realtor, and I was still in title at that time. I had a realtor call me and she goes, and she was representing the seller. And she goes, we have a cash offer, and it's a better offer than what we turned in. Have they turned in earnest money yet? And I said, not yet. And it was about day 3, about 4 o'clock. Okay? She goes, good. She was just waiting. She said, good. Well, that other realtor was really busy and it just assumed that their client dropped that money off because your clients don't understand 3 days. Well, maybe 3.5 or 4, but 3 days. Okay. So at 5:01, that realtor walked in because she called us and said, I'm coming in with another offer. So she came in, dropped it in. Obviously, she's going to have the other one. There was no earnest money or option money. So are you in compliance with that first contract? No, you're not. So she turned in that one. The next morning, the realtor comes in and has the earnest money and option money. And I went, okay, we got a problem. We didn't get that. Didn't you get that termination from that seller? And she goes, no, I didn't. So people watch that. And realtors watch those 3 days, and if they have another offer, they're going to come in right after that and get that taken care of. So watch that. Don't assume your client knows and is going to get that to the title company, okay? Watch that 3 days. Inspections, appraisal, and securing financing, and the survey. If you're going to, usually title companies order the survey, but if you said, no, my client's going to order a survey, which I never recommend that at all, ever, ever, ever. Always get title company to order that. You know, you may have to fill out a form saying that, yes, my buyer's going to pay for it or my seller's going to pay for it, so they're off the hook. But get them to order it because the surveyor is going to need Schedule B to finish the survey, and if they ask that for your buyer, they're going to go, I have no idea, and probably not get it to them. So make sure that the survey is done and done in a timely manner. Has anybody ever ordered a survey or had a title company on a survey for meets and bounds? It takes at least 2 or 3 weeks to get that done. And if it's bad weather, they can't get it done because they can't go out there and they can't find the pins. So make sure that you have those dates to where you know that that's due and you get that information. Power of attorney, mail outs, and heirship affidavits. Mail out is a big deal. So if you have a mail out, let's say for instance, you have someone that's in the Army and it's your buyer or your seller and they're overseas, but they have to sign the documents. There's no power of attorney, they're going to sign the document. So you tell the title company, they're going to have to say, I've got a mail out. If they're overseas, they have to go to where? Embassy. They have to go to an American embassy and have those notarized by an American notary. All right? Do you know how hard it is to get? You would think that there would be one, 8 hours a day. You could just walk into the embassy and say, hey, I need an American notary. It does not happen that way. You have to make an appointment. And sometimes it takes 6 weeks to 8 weeks to 3 months to get those appointments, okay? They're not just sitting there willing to do that. It takes time. It takes an appointment. So if they say they're overseas, go, okay, we need to make those appointments now. We need to make sure that we can get maybe whatever it has to be notarized to them or make sure that they have that appointment set up right before closing or they can get it and then mail it back and overnight it back to the title company. Has anybody ever had a delay on mail outs? I'm sure Cindy had. If you've been doing this long enough, you're going to have, just because people don't realize they have to go to an American notary or to a notary to get them signed. Used to, you could walk into UPS and they will sign, their notary. Now they won't do title docs or lender docs. Just keep that aware. They won't do them. So you may have to go to a bank to get that done. So a lot of people, it's because it's a liability issue. They don't want to do that anymore. So make sure that you get those mail outs and make sure everybody's aware of it. You get it all done prior to. Title commitment. Make notes that when you need that title commitment, make sure you are getting that in a timely manner. Now, I don't think it takes this long. Is it still maybe like 10 days, 10 business days? Maybe? You're not shaking your head? Yeah? Yeah? Okay. 10 business days. All right, and then closing. Make sure everybody knows when they need to show up and where they need to show up. Okay. All right, big piece of a puzzle to closing on time is staying on top of the mortgage process. Also, staying on top of the commitment. Make notes of all dates and follow up with those responsible to ensure no one has dropped the ball. If you're on the seller side, you'll want to make sure the buyer side is sticking to the contract. Don't ever assume they are. Don't ever think, well, she's been doing real estate for a long time. She's got it. No, call the title company and say, do you have everything from that other realtor or that buyer or seller? Make sure you do. because the realtor may not know that their client's not getting that to them. Okay, timelines. You'll make sure your clients are getting all needed financial documents, other needed information to the lender and title company. Title docs, LLCs, trusts, wills, unrecorded easements, deeds, and divorce decrees. All right, so wills. Even though you're going to need an heirship affidavit, but you have an old will, turn in that will anyway, although it's not probated, but turn it into title, because examiners are going to pull information from that will, and they're going to look at the heirship to make sure it matches. Okay, does that make sense? Okay, question. Can someone tell me why the title company may not find certain recorded documents, like a divorce decree, while doing the title search? Oh, that's a good one. Anybody? Okay, so title searches are done where? Title searches are done in property records. Divorce decrees are filed in public records. Title companies do not have access to public records. That's why they say, when you say we got a divorce, well, I need a copy of the divorce decree, you think, well, it's filed, why can't you find it? Well, they don't. That's not where they're going to look. They don't have access to that. So anything that's going to be filed a public record, like will's been probated, or divorce decrees, they're going to need a copy of it. Two, sometimes people don't always get divorced in the same county. They might have gotten divorced in California or whatever. They're still going to need a recorded copy of that divorce decree. Recorded copy signed off by the judge. Okay, remember that. Don't come in with something that hadn't been signed or hadn't been recorded. All right. Any questions on that? Yeah, flying right through. Title search and examination. Okay. Remember, title companies go by what? Legal descriptions, not by property addresses. And I remember getting something or calling a realtor, or actually she called me, and she said, you guys examined the wrong property. You didn't examine, it was supposed to be, there was several other lots, but there wasn't enough room for her to write that in the legal description, but she said, but I had the property address on there. Title's not going to look at property. Title's not even going to look to see if it's the right property or anything like that. They're going to look at the legal description, and they're going to examine by that legal description, okay? So, yes, you got to have the property address on the contract, but more importantly, need the right, correct legal address. So make sure the full legal is on the contract. If you don't have room to write it on there, then create an Exhibit A as a legal description, okay? Create that, attach to the contract. You're going to put in there, see Exhibit A, and then where else are you going to put that? The page with all the, on the contract with all the addendums, you're going to check Other, and you're going to check Exhibit A, because it's an attachment. Okay? All right. Title search, we're going to find mortgages, judgments, and other liens attached to the property. Some searchers may discover special building restrictions buyers unaware of. That's why it's so important. We'll go over commitment in a minute. Along with HOA liens, assessments, additional taxes, easements, or encroachments. Also heirs, not party to the contract, along with countless of other issues that they can find examining. If there's any restrictions on Schedule B, request copies of them and get them to your buyers. Make sure you have an email or something in writing that your client has confirmed that they have received those restrictions and they know to read them. So as far as restrictions and everything, if you are selling to a buyer and your buyer is, has a property that they're interested in and they have restrictions, get those restrictions ahead of time before you make that offer, because there could be something in restrictions that they don't want that property anymore. So before, you don't want to wait till title comes out, then you've got 3 weeks into it or whatever, and you've wasted time, and she goes, oh, or you can't put a chicken coop in that, or you can't put whatever. Then if those restrictions are in there, don't waste their time or your time. Make sure you get that ahead of time, okay? Title search for new construction and undeveloped properties. This can be quite time consuming, guys. So make sure that you allow plenty of time, even though everybody thinks, well, it's cash, I can close in 10 days. No. If cash, great. You don't have to deal with a lender, However, you still got to get the examination and the title search. So you got to make sure you have that time. While the actual structure may be new, the land of which it resides has likely transferred hands countless of times prior to the new construction, making ownership issues and possibility down the road. So again, sometimes you would think it would take, it's a quick search, it is not. Additionally, with respect to newly built home, there is no guarantee the subcontractors or suppliers have not placed liens on the property. Anybody have sold a new build and seen mechanics liens on Schedule C? It happens. Sometimes builders don't pay their contractors, so they file a mechanics lien on the property, and when they do that, those have to be paid at closing. So watch those as well. Of course, all those liens would need to be paid at closing or released before issuing a policy. So title insurance, which you have to, there's no like right or wrong, like there's, when a title underwriter decides to insure a piece of property, they're not looking like at a book from TDI and say, well, I can't do this, I can do this. They look at it as a risk, an insurance risk. Same, let's say if you had 10 accidents and 5 tickets, and it's going to be hard to get car insurance, isn't it? Because you're a high risk, all right? So if a title underwriter looks at the examination and looks at all the title search and they see that there is a cloud on title, all right, that it might have been 30 or 40 years ago, there was a missing heir, there's been deeds since then, but there is a missing heir. They look at it and say, okay, am I willing to take the risk to insure this property? Sometimes they do, and sometimes they don't. So it's not right or wrong. It's just, are they willing to take that risk? If you go to a title company and you turn in a contract and that title underwriter says, I'm not willing to insure this, and you take it to another title company and they say, okay, we'll insure it. Go, oh my God, what's wrong with that title company? The difference is some title companies have one underwriter. And if that underwriter says, I'm not going to insure it, they're not going to insure it. But some title companies have 6 or 7 underwriters. So they'll send it to an underwriter that are more lenient. And they'll look at it and go, okay, I'm willing to take that risk. And they're willing to insure it. If you take it to someone that has 7 underwriters and all of them say no, you're probably not going to get it closed. All right? Just keep that in mind. Don't think that title company can take anything there. They'll close anything. No, that's not the case. They just found a title underwriter that's willing to take that risk. Does that make sense? Okay, good. Question. All right, now we're getting any questions on title search? I know we're covering a lot, so just stop me if I'm going too fast or anything. Question. The residential real property affidavit form is a T64, a T19, or a T47? What's the answer to that question? T47? T47. And so I have this on I have another class that it's called, we play Jeopardy. And so this was one of my questions. And they're like, I know that, but do I know that? Because you think of it as what? The T47, you don't think of it as a real name, and it's the residential real property affidavit form. That's your T47. And yes, there is a T64, and yes, there is a T19. But the answer is T47. All right. Survey, plat, and T47 affidavits. It's imperative for the seller's agent to ensure that the seller has an existing survey before accepting an offer. If your seller says, yep, I got a survey, I want to see it now, and I want to make sure it's a survey. Because I've seen situations to where a realtor brings in the offer and brings in what they think is a survey, and it's a plat. Or it might be a copy of a survey, but it's missing the bottom part, which is like the signature and things like that. It's cut off. We're like, can't use it. So before you accept an offer, because sometimes you say in the contract, you say, yeah, I've got an existing survey. And they say, well, if title doesn't don't want to insure with that survey, then you agree to buy another one. Yeah, sure, we're okay because we've got an existing one. No. I've seen so many times where we get to closing and they realize that the survey had to buy a new one, and it's on the seller side as a cost, and sometimes $1,300, $1,400, and they go, I didn't agree to that. Yeah, you did. Well, I turned in a survey. It wasn't acceptable to title. So make sure it is. Just send it over to them. Walk in with them and say, do you think this will be okay with the underwriter? The underwriter makes that decision. However, an examiner probably can look at it and tell you if it's going to be acceptable or not, okay? Survey, the process by which a parcel of land is measured and its boundaries and contents ascertained. Plat is a map drawn to scale showing the division of a piece of land, all right? How they differ. A survey will show any dwellings, buildings, or improvements like driveways, fences, pools located on the property. A plat usually shows the dimensions of the property before the improvements are made. A plat will often cover more than one lot, a parcel of land. For example, a developer will have an entire subdivision drawn. Survey usually only shows one lot or the lots adjacent to it. Plats are often drawn in order to be recorded. If you see something and it has recording information on it, it's a plat. What is this? Is it a plat or a survey? Plat. All right. Survey or plat? Survey. Okay. You see the difference. And also they have they even drew out because of, this is a good survey because they even drew out more detail on the side. Here's another one. Plat or survey? Survey. Absolutely. Okay, couple of things. Survey or plat. So everybody's good with that. Again, yes, question.
Are field notes required on a survey for plat?
Okay, so that's a good question. So some surveys, I think I have it in here, but I'll go ahead and talk about it. Sometimes you'll see a survey that says unexamined or usually they say unabstracted on the survey. It's not going to have field notes. That means that that surveyor just went out and surveyed that property and didn't do any examination, didn't do any abstracting. On a survey that is abstracted, they should have all the restrictions, all easements, all building lines, any issues. And that's why if it's abstracted, the surveyor needs Schedule B, because Schedule B shows everything that affects that property. So they need to show and make sure that they didn't miss anything while they abstracted. So to finish it, they may make sure, okay, restrictions are right, because they got to have the volume and page. Easements are going to have the volume and page. They want to make sure that it all matches. Sometimes the surveyor may abstract and find something that title missed, or vice versa. Then they got to add it. Sometimes they'll call and say, look, I surveyed it. I didn't see that. Where did you see that? Volume and page. I'm not finding it. And it could be the wrong property. So they'll talk to each other and make sure. Now, if you have a survey that says unabstracted, you're probably going to need a new one. Okay? Because it's just a drawing of the property. Title's probably not going to insure it, and the lender's not going to want it either.
And what if field notes are just missing? Like say they have a survey, but the seller does not have a copy of those field notes.
Okay, you're talking about field notes, you're talking about that's attached to it. Okay, so you're still going to need them. So you could probably call the, yeah, you could call the surveyor, and they may say, yeah, I've got it. Because if he was, sometimes they just keep the survey and don't keep the field notes that's attached to the survey, because it's sometimes just a piece of paper. Then they're going to need that. Title's going to need both. Especially if it says see field notes, they're going to need both. Okay? So, any questions on surveys? I'm going to talk a little bit more about them, but first I'll talk a little bit about T47s. If the seller has an existing survey, title must be furnished with a T47. Do it at the same time. Don't turn in a survey and then a week later turn in your T47, because title is not going to look at that survey until they get that T47. They're not going to look at it, because that T47 tells them what? If there's any changes that are made. So title's waiting on any changes. Can we insure this? What's going to happen? We got to wait. So turn both in at the same time. T47, to be familiar with the property. Okay, if there have been changes to the property since the date of the survey, such as construction of any permanent improvements, changes, fences, or boundary lines. If your client, you said, did I make any changes when we put a new fence in? You're going to have a new survey. Title looks at new fences are going to change the boundary line. Even though they say, well, they followed it, they may not have, because that survey was done on that fence, not on the other one. Construction of adjoining property, conveyance, replats, easements added. If any easements or things like that, you're probably going to need, that has to be added to the T47. Any other change to the property character since the date of the surgery. Yeah. Any such items must be listed in detail on the affidavit. Do not instruct your sellers to draw anything in. Now, title may ask them to do it at closing. That's fine. But don't say, well, I had one closer not too long ago and they allowed, it's the same title company, they allowed the guy to draw in a pool. Don't draw anything in unless title says, seller, I want you to draw it in, and they'll probably be sitting in front of you seeing where it is, okay? All right. Question, what should the seller write in the space on the T47 when asked? To the best of my actual knowledge and belief, since blank, there have been no change. What should be? What's the date? Date of the survey. Date of the survey. Title underwriter is going to require the date of the survey, not the date that they closed. Because let's say they're using a prior survey and a prior affidavit, and they closed, it was since like 2005, and they closed in 2010. And they're like, well, I don't know. I can't put anything before 2010. You're going to have to put the date of the survey. And the thing about it is you have an affidavit from that seller saying there's no changes. So they don't need to think that, well, I can't say that. You can say that. You have a T47 which you closed on saying there were no changes or these were the changes, okay? It has to be the date of the survey, all right? Date of the survey. Okay. Surveys and copyright laws. So, has anybody run into this? Surveys and copyright laws for surveys. Everybody knows what a copyright law is, right? For instance, it's the same law in Texas. If music, you're not allowed to use music because it's got a copyright. So it's a copyright law. It's the same thing. So I see more of this in the Dallas-Fort Worth area, but I got a call from a realtor in Longview, and now it looks like they're happening here. So he said, why? So when I got in title in 1988, that was a long time ago. So when I got in title, you had to have a new survey for every closing. Every closing. So surveyors will make a lot of money because for every closing, you'd have a new survey. Then TDI says, Texas Department of Insurance says, you know what? You really don't need one for every closing. Let's say you can use one, but not any older than 7 years. That was done in like 95 or 96. And so, okay, so 7 years. Why 7 years? I don't know. And then a couple of years after that, they said, you know what, it really doesn't matter. If it's accepted by a title underwriter, then it doesn't matter how old it is. So surveyors didn't make as much money doing that. You see where I'm? Okay. So now they have figured out, and if there's a survey in here, I apologize. I completely understand. They're putting copyright stamps and copyrights on these surveys. So if you have a survey that your seller has and there's a copyright on there, it'll say you can only use this survey for this closing with this with this buyer. All right? So if a title underwriter gets it, they may come back and say and it'll say on Schedule B, we need permission because it has a copyright law on it, copyright stamp. This isn't the same buyer, it's a different transaction. We need permission from this surveyor to use this survey. So when that agent called that surveyor, the surveyor said, nope, you're going to have to get a new one. I'll be happy to do it. I can get it to you quicker because I have all the notes. They had no choice. They had to. So you might be able to get one. You may pay $100 or they may say, you know what, yes, go ahead. Just depends, but just watch them. If you have a survey that has a copyright information on there, then you're going to need to make that call to that surveyor and say, hey, can we use this? All right, because the underwriter is going to see it. Now, there's no case law on it right now, so meaning that nothing's been sent to court because someone's used it. So I don't know the ramifications. I don't know. Trek hasn't said anything about it. Just want to make you aware of it. So if it says that on one, title underwriter doesn't ask, that means they're willing to take that risk. Okay? You're good, because that owner's policy is going to cover that. All right? Any questions on Barbara? They probably will if they put the one on before. And if you call them and say, I need a new survey, I would go ahead and ask them to do it because they've got all the notes and they can probably do it a little quicker and they may do it a little cheaper. That's one way of them getting business, you know. But, and they may not, you know, obviously they have all the notes. They may not need to go out and resurvey it, so it might be a little cheaper. But I know that in this case, they did that. I don't know how much cheaper it was, but they did ask and they did require a new survey. That underwriter did. So, but I've heard that I had another realtor, it was in a class I was teaching, and she goes, I had one, the underwriter didn't say anything. So again, they were willing to take that risk. It's going to be that title underwriter making that decision, all right? Okay, so if you know, let's say for instance, if you have a closing team and you get one and you see that it says there's a copyright on it, then call your closing team and say, hey, can I bring this up here? Can you send it through your title underwriter and see will they accept it? Well, you know up front what to fill out in that information on the contract, because you don't want to put check that you've got an old one where you know you can't use it, that you're going to need a new one, because if you need a new one, who's going to pay for it? You're going to want the buyer to pay for it, right? You don't want the seller on the hook for it. So your closing team's going to know, the title examiner is going to know, or the underwriter who makes the decisions, okay? Any questions? Anybody had one with a copyright on it? You did? Yeah, I know it. So apparently they're going to be, in the Dallas-Fort Worth area, there are going to be a lot of them. I hear about it a lot because I teach in Rockwall and Rowlett. I have that territory too. So like I said, we see them all the time. So. They do. They go out of business. And the reason, yeah. So, yeah, they do go out of business, and just because obviously the business wasn't as good as it was before, because they can use prior surveys. And title underwriters are getting more relaxed on surveys because there really hasn't been a lot of, less claims on them. So before they were like, oh, they're really strict. They're really getting more relaxed with that. But again, there's no case law with the copyright, so they're probably not wanting to be the case law. So don't blame them. Okay. Any questions on surveys and plats? Okay. Title commitments. So you read those title commitments, A, B, and C, right? Read them cover to cover. If you don't, you need to. Please read them cover to cover, okay? And I taught a class, title commitments, in here last month. And I'll come back and teach it again because it's part of your business. It's so important for you to read them. Reviewing the title commitment with your buyer, seller, never advise them. If you're reading that and they call you, send it to them, and they call you, go, what does this mean? If you don't know exactly what that means, please tell them to call the closing team or the examiner, someone that can tell them, because again, you may be practicing law or you may be explaining them to something that really isn't true, all right? It's not your world. Don't think of it, God, I can't believe I don't know the answer to that question. That's okay. That's not your world. Get it to somebody that can, okay? The day you turn in a contract, make notes as to when you should be getting those commitments. Now, a lot of title companies here in this area used to, all they had access was Smith County, but East Texas Title was gracious enough to have allowed them to buy into their other counties. So even though you may take something to one title company, it may be Cherokee County, they now have access to other plants. So it may not take as long, because if anybody ever knew before 2020, you turned something in Cherokee County, it was going to be a 60-day closing. It was awful, awful. Well, now the examiners here have access to those documents, so it might not take that long, okay? But just keep that in mind, because it does take a while. You know, oh, well, I won't get into that, because when I was in title in Dallas, Fort Worth for 27 years, it took us 3 days, 5 business days at the most. And I moved to East Texas, and I'm like, how long does it take y'all to get? And they're like, oh, 15 days. I was like, why does it take 15 days? I won't go there, but I can't, it's still, it probably won't be forever. Just keep that in mind. Schedule A of the title commitment sets forth the following information. Start with Schedule A. Don't go to C. Think I'm going to go straight to C and see if I'm going to close. Start with A. A is going to be the effective day of the title commitment, your GF number, policy amounts for your mortgage and owners. Type of policies amounts are sales price and loan amount. So for your mortgage, it's going to be the loan amount. If it doesn't match the contract, you need to make a phone call because somebody's made a mistake. Sales price should be the owner's policy. If that doesn't match, make a mistake. I got one title commitment one time, and the house was $320,000, and the mortgage was $3 million. The person that put in the order just put in a 0. All right? And I knew that wasn't right, so immediately make those calls. All right. Names of the proposed insureds, make sure they're spelled correctly. Make sure the who vested sellers match. If you have a contract that says Bob Smith and you get a title commitment that says Bob and Sue Smith, you have a problem. Who is Sue? First question you're going to call and find that title. Who's Sue? Is it a deceased wife? Is it an ex-wife? Is it a co-signer? Could be mother, could be sister. Who's Sue? Because Sue's got to be part of that, what? That contract. We got to find Sue. We got to find out what it's going to take to get Sue on that contract, and if they're deceased, you got more problems than that. So legal description of the property, make sure it's correct. I've closed on the wrong properties before because lot and block were switched. You know, the title industry, since I got in it, the process has never changed. There's one person or two people who put in that order. You know, you would think over so many years that the process is going to change. It doesn't. Doesn't matter where you go, it's the same process here in Texas. At one or two people put in those orders, so they've got them flipped, lot and block flipped. It happens. Here it happens. So watch for it, because if you don't catch those mistakes right at first, your lender is going to cut and paste that legal description. If they cut and paste that legal description on all of their documents, then what? Not only are you closing the wrong property, the mortgage is on the wrong property, and you're going to have to reclose everything. So catch those mistakes before it happens. Question. Will the new owners of title policy cover items on Schedule B? So for the new owner's policy, will Schedule B, or will they be covered on items on Schedule B? Answer is no. Remember, Schedule B is exceptions. Schedule B says, that's why your buyer needs to read Schedule B, because Schedule B, think of borders, boundaries, and buyer's notification. These are things that the buyer's buying this property, of all of this stuff. There's an easement, there's restrictions, and it says, you know what, I'm letting you know that your buyer's buying all this due to all of this that's attached to the property, but you're not being insured. There are exceptions to the owner's policy. All right, so make sure that you know that if there's an easement. I got a call from a realtor the other day. Is she in here? She called me and she said, nope. She said, I've got all of, oh, she's funny. She's like, I'm looking at Schedule B like you told me to, and there's all these easements. Can I read them to you? And so she read them. One of them was the phone company. Oh yeah, I mean, it's a buried line, it's the easement. One of them was another, easement where the electric company could get on the property. That's standard. Okay. And she goes, and here's the one. It says husband and wife easement. I went, whoa. Wait a minute. I said, what? She goes, it says husband and wife easement. I said, who husband and wife? She goes, oh no, it says husband and wife and a volume and a page. I said, you need to get a copy of that. Because I said, I have no idea what it is and who knows what it says. So your buyer needs to get a copy of that easement to see if husband and wife, who husband and wife? Is it the neighbor, husband and wife? Can they come on the property? Maybe they have an adjoining property on the other side. Can they come from, travel through their property to get to the other lot? What does that easement say? Because whatever it says, it's not going to be insured and it affects the property. So you need to pull them. You need to go over with your buyer to see, because you don't want your buyer to move in. And this has happened. Buyer moves in. I think she bought like 10 acres. She moves in, and about a month later, she sees this big dump truck traveling through her property to get dirt that's in the back acres. So she calls the realtor calls me, and I look up, Schedule B, yep, there's an easement right there. It says they can do it. She goes, so what does that mean? That means they can come get dirt as long as they want, as long as it's there. And she goes, well, the buyer wants to sue everybody. I said, well, got a problem then, because it was on Schedule B and the buyer was notified. So good luck. So make sure that they read Schedule B. If you have any questions, get those documents from title. I just gave you that example. Again, the CCRs, going to be covenants, conditions, and restrictions. Case of an HOA information, all right? POA, Property Owners Associations, your PUDs, Planned Unit Development, they're all going to be on there. They're all going to be on Schedule B. A new buyer buying the property subject to the rules and regulations documented in your CCRs, which are your restrictions. That's why it's so important to read Schedule B, all right? Look at that and get those documents, because that's what they're buying. Any questions on Schedule B? Schedule C, can thought of clear to close, okay? I did it, and I put my check or my to-do list. It's usually what I called it, my to-do list, because Schedule C says all of this information has to be cleared up prior to closing or at closing, all right? There's liens on the property, anything like that, it needs to be taken care of prior to or at closing. Super liens have to be paid off at closing. What's a super lien? Mortgages, IRS liens, child support liens, taxes, property tax liens. That's all got to be cleared before closing, okay? Now, there's judgments. Sometimes there's judgments on the property. So whatever you do, if you look at Schedule C and you see all of this information, there's judgments and everything, don't tell your clients that everything has to be paid off at closing. I'll tell you a quick story, if I have time. All right, quick story. So there was a realtor, and it was one of my offices in Dallas, and she saw a judgment, an abstract of judgment on her seller, $40,000 from Sears. So she said, you're going to have to pay it off at closing. Typed up, you're going to have to pay this off at closing, get the payoff information to title. So she sent me an email and said, this is going to be paid off at closing. He's going to get you the information. So I said, okay. So we collected, paid off at closing. Fast forward, it was a couple months later, she threw a Christmas party every year for her clients, and I was there because I was her closer. So the client who had just paid off that lien was talking to a realtor. An attorney. And he goes, hey, I saw you sold your house. And he goes, yeah, I did. He goes, I got a question. I had to pay off an abstract of judgment. Well, do they really have to be paid off at closing? He goes, well, sometimes they don't. He said, sometimes they do. Send me the information and let me see if it has to be paid off. And so what happened, it was with Sears. And because of this guy had other assets, all right, Sears agreed to do a payment plan with him and to do a partial release. They would have a partial release of lien from that property and attach that lien to other properties, because chances were they probably would have gotten their money, all right? But he didn't have to pay it off. So what did he do? Filed suit against everybody because his realtor told him he had to pay it off. And he had an email that she said he had to pay it off. So it was a big mess. She lost. She wrote a check. It was awful. Whatever you do, don't tell them they have to be paid at closing. Tell them if you have any questions, you're going to need to get payoff information to title, and they'll be able to help you. Okay? Remember that. It was a sad situation. Anything on Schedule C? Okay. You'll remember that Christmas party, too. I'll never forget it. CDAs, and of course there was an attorney there. Of course it was. CDAs, invoices, HOAs, home warranty, seller payoff information. All right, commissions. What is the first thing that you should look at when you get your closing disclosure or your HUD? Commission. Commission. Come on, guys. The first thing you do is you look at commission. Don't assume that title's got it on there, and don't assume it's right. Because what happens is they prepare all the documents, and then the day of closing or the night before, they get a CDA from you. And the CDA actually has 4.5% instead of 3% or whatever, and the amount's wrong. Well, they have it in the bin where it's ready to close, and they have 9 closings that day. She's going to grab that one, close it, that one, close it, that one, close it, and the next day she's going to look at her emails. So don't assume that it's right. I have missed commissions. I have put wrong information on it, and they haven't been caught till after closing. Good luck trying to go to a seller and try to get money. It's ugly. Has anybody in here had the wrong, I'm sure if you've been doing it, Cindy, yeah. First thing you look at is at your commission. Make sure it's right, make sure it's on there. All right? Don't forget that's the first thing. Next thing you're going to look at is make sure your repair invoices are on there. Make sure if it's said in an amendment or per contract and the lender agreed to it, that the seller's supposed to provide $5,000 for a new AC unit to the buyer. Make sure it's on there. I had a deal the other day. They were supposed to. They didn't do it. Wasn't collected. The amendment was missed by title. They filed a claim to get a new AC because it didn't work per home inspection. And she goes, oh my God, I forgot there was $5,000 that was supposed to be on I was supposed to get, and I didn't get it. She calls title. Seller goes, sorry, good luck. Make sure it's on there, guys. HOA information, make sure that's correct. Make sure it's on there. Home warranty. Now that I'm doing home warranties, I can tell you I've had so many calls where it was supposed to be collected and title missed it. It's just an invoice, they're going to miss it. They missed it. If they missed it, then there's nothing I can do. I'm going to call title and say, was it per contract? Yes, it was per contract. Try to get it from the seller. You got to work with title to get that. Get me the check information and I can get it activated immediately, but I'm going to need a check, all right, showing that they're going to pay. If it's not per contract, if the buyer says they're going to pay for it, make sure they pay it at closing. Had one the other day. Buyer said, yeah, I'll pay it. Seller's not going to pay, but I'll do it. Send it title invoice because it wasn't part of the contract. They didn't collect it on the closing disclosure. So she just like, oh, well, I guess they're going to take care of it outside of closing. They didn't. And he didn't have a home warranty. So make sure that we get that. Payoff information. Make sure all payoffs are on there and make sure that title has all that information. All right, don't forget your commission and those invoices and everything. And I know it's kind of like whatever you do, when you get the closing disclosure, don't wait till, well, I'll look at it at closing. Because what happens is you're sitting at closing, that closer's going so fast, you look at it, you look over it and go, I guess everything's there. Because your number one is your client. Try to make your client happy, try to make your client comfortable. You're not going to look at that closing disclosure and find a mistake. You're going too fast. You're going to assume everything's on there, and it may not be. Probably more than not, I will tell you that, especially if they're busy. Tax prorations. True or false? If your closing is scheduled for May, the proration of tax is an estimate based on prior year amounts because the actual taxes for the year are unknown until the tax statements are received in October. True or false? True. True. Okay, so in Texas, in Smith County, they're only collected one time a year, all right? So in October, when the statements come out, then they will ensure that they're going to collect 2023 property taxes. But if they're not out, they'll be collecting on the year before. So you're like, well, it's not a big deal. It can be a big deal because it could be a big difference in the amounts, okay? But there's no way of getting around that because that's what they have to go by, all right? Example, Last year, taxes were $12,000. The closing to sell the property occurred in June 30th of this year. The seller will be responsible for taxes from January 1st to June 30th, okay? At closing, the buyer receives a credit for $6,000 from the seller because it's prorated, because they can't pay. So title can't collect it because they can't pay. Number one, they don't know how much to collect. Number two, they can't collect it. So they give a proration. It's a debit and a credit, all right? It is shown as a debit, seller, credit to the buyer on the closing disclosure or HUD. When taxes are due, the buyer will receive a statement from the tax authorities for the entire year. So make sure you have this conversation with your buyers, because the check isn't handed to them, it's less money they bring to the table, they don't realize it's a credit. And when they get the bill for $12,000 and they go, wait a minute, I only own this house for 6 months. How come I'm responsible for that? Well, you got a credit at closing. And so I can't tell you how many times I've talked to a buyer on the phone, because the realtors say, call the title company, which you should. They'll explain prorations to you. And I'll say, look, it wasn't money that you were handed a check, but it was a credit. Well, I don't understand that, and I don't know why I'm responsible for the entire year. Now, if they have a loan, a mortgage, the escrow is going to pay it. So they're probably not going to call you, because escrow is going to pay it, and it's probably not going to be missed. But if it's a cash transaction, you're going to get that phone call, go, why am I paying the entire year? It's because you can't collect it until they're due. But make sure at closing, when that closer's going over that HUD or closing disclosure, they point out the prorations, and you say, remember we had this conversation. Remember, this is that credit you're getting, and you're going to be responsible for the entire year. So at that time, they can ask the questions. Don't wait till they get that invoice, okay? All right. Because has anybody gotten the phone call? I know you guys have. Barbara, I know you've gotten that phone. Vicki, I know you've got the phone call, because buyers don't understand that, especially if they're new home. And they forget. Yeah, and they go, why am I paying for the full year? I've only owned the house. Where you got a credit. I didn't get any money. Yeah, you did. Okay, here's another example. Let's say that the actual taxes on property increased $100 per month, because remember, when they're collecting it, they only have prior year. They don't have the new year. So this happens. So instead of they got a $6,000 credit, they should have received more money because it went up. So now the taxes are actually $13,200 and not $12,000. So the buyer's going to be upset about that. And if they have an escrow account that's not going to, with a lender, it's not going to even be missed, because that's why they collect a 2-month cushion. So in case there's a difference, they have that money in there. So if they have a lender, not to worry about it. But if it's if they don't have, it was cash, or they're paying their taxes outside of their lender, then you make sure they understand that. There's nothing you can do. Tell them to call title. There's nothing you can do. Closing disclosure, also CD. True or false? The closing disclosure replaced the truth and lending disclosure and the note. True or false? False. It's truth and lending and the HUD one. And why they made those changes, I'll never know, but they did. It's ridiculous, and it's still more confusing than the truth and lending was. In 2015, the CFPB decided, they took over HUD, and they said, okay, we're going to make some changes. We're going to take out the truth and lending because it's too hard to understand. We're going to put it all on the closing disclosure, but it's still too hard to understand. So I'm not sure why. Review. Take the time to read through that CD, look for mistakes. Commission, missing home warranty, repairs, misspelled names. If you look at it and get that closing disclosure and your buyers or your sellers misspelled, every document from that on, when you get to the closing table, it's too late to change it. And sometimes you can't just mark it out and initial it. Sometimes lenders say, no, we got to redraw, so you're going to have to postpone it. The numbers are not correct. If you're working for a seller, you have a pretty good idea of what they're supposed to get. If it's within maybe $1,000, you may call the title and say, where did I miss? All right. If it's 10, 20,000, call title and say, what? Okay, there's a big discrepancy here. And sometimes it's the payoff. Sometimes sellers think they owe this much, but they really owe this much. So sometimes that's what it is, but just make sure you know what it is, because when they see that closing disclosure and they're supposed to get $6,000 and they're getting $2 million, they're going to look at you and go, you told me $6 million. What's the issue? Make sure you take care of that before you get to the table, all right? Because it could be title's mistake. Get the corrections made prior to closing. Authorization. So if you call and ask for a copy of the closing disclosure, and that title company tells you you can't have a copy of it because it's the lender's, and you need to contact the lender, you tell them that very politely they're wrong. That now the third-party finance addendum was changed in 2019, and it added number 5, authorization to release information. And it says, because if there's a loan, buyer and seller both sign it. They have to, it's part of the contract. Authorization to release information. Buyer authorizes buyer's lender to furnish to seller or buyer or their representatives information relating to the status of the approval for the financing. Seller and buyer authorize buyer's lender, title company, escrow agent to disclose and furnish a copy of the closing disclosures and settlement statements provided in relation to the closing of this sale to the parties, respective brokers and sales agents provided under broker information, period, end of conversation. You do not need permission. They sign it, circle it, send it back to them, because they may not know. I didn't know till I was notified that this happened, so you don't have to have permission now. They're off the hook. Did everybody know that? No? Good. At least learn something today. How to prepare your buyers and seller for closings. Make sure your closing checklist, spouse or cosigner, cashier's check. You can't, TDI says nothing over $14.99. Title companies may not take personal checks at all at closing. Make sure you ask them, okay? Valid government issued photo ID. If their birthday was yesterday and it expired yesterday, it's not valid today, okay? Had people come into closing, well, my birthday was yesterday, so it expired. Well, it's not valid. It is not valid. So make sure you get it before buyer leaves. Title company, make sure they have copies of signed documents, certified copy of the warranty deed, keys made prior arrangements, home warranty information. Make sure the buyers receive and understand the CD and HUD prior to closing, and all passwords and codes to any smart devices that are conveying with the property. That's per contract now. They have to have that. Make sure they have it. Seller, make sure they have a valid ID. Make sure they bring their spouse or anyone else who purchased the property with them. Voided check for wire proceeds. Keys, garage door openers, security gates, and codes. Access information, smart locks, thermostats, doorbell, appliances, any of that that's conveying with the property, make sure you get that, because it's per contract and per that addendum now. Any other remotes or devices that control systems in the house, and a cashier's check if they have to bring money to the table. Common real estate closings, the delays, buyer's money delayed. I can't tell you, seller spouse. Surprise notifications, restrictions, POAs, mail out, repairs not completed, payoffs, buyer's marital status, buyer's job status, and lender's underwriting requirements at the last minute. Was in closing, happened several times over my years, and get there and buyer sits down, and they were fiance and they were, buying the house, and they were going to get married a month, but they decided to get married the week before. Why? And they said, congratulations, we got married. Yep, you're not going to close now. You're going to have to redo everything because they're a married couple. So that changes everything. Tell them, don't get married till after you close. Closed versus funded. There's a difference. Closed versus funded. Closed means your client signed all the documents. Funded means the lender has, if there's a lender involved, lender has given funding authorization. Some of them require the entire package to be faxed over or scanned. Some of them require just a few documents. Just depends on the lender. And a cash transaction, it's funded when all the money is there, all the buyer's money is there at the title company, and they can actually cut checks. Table funding, doesn't happen very often. It's a local lender. Sometimes they'll bring a check to closing. They'll witness a document signed, and they say, okay, you can fund, and here's the money, okay? But just because you closed doesn't mean you're funded, all right? When can my client receive the keys? Possession, whatever spelled out possession, you know, and I would leave title out of that loop because they really don't like to, you know, if their buyer says, I'm going to come back and get keys and all the, you know, documents or everything, maybe they can put a package up front, but don't leave them responsible. If the closing, if it's the end of the month, they get busy and there's a set of keys there and they go, oh my God, I haven't forgotten whose keys these are. You know, they don't leave them responsible for them. Handle those on your own to make sure that they get them. All right? Any questions? Did anybody learn? Yes.
Sorry.
No.
So at closing, you can't use cash or personal check over, or like right under 15,000. So if you're
14.99, 1,500. 1,500.
Okay, that's good to know. So what if it's a cash sale? What
Certified funds or wire, and I would say wire. Yeah, title company's going to. That's a TDI rule, not money orders. Money orders, not guaranteed funds, and that's what it is. And that's per contract number 18 under escrow. They're required now for good funds. Some TDI says $14.99. Anything over that cannot be done at closing. It has to be either a wire or a cashier's check. But some title companies don't like to take personal checks at all at closing. So if they tell you that, then you can't. Okay. Sometimes they make their own rules just because they've been burned before. And the reason why is because if you get it drop off, for obvious reasons, drop off an earnest money and it's a personal check, it's going to have time to clear. If you write a personal check at closing and the lender says you're funded and it's a done deal, and then a week later that check bounces and it comes back, title's going to have a really hard time coming after those people. Okay, so you can't go and say you can't move in and they've already moved in. So make sure you know what your closing team wants. Any other questions? Anybody learn anything today? I hope so. I hope so. Thank you guys so much. I appreciate it.